This tutorial is produced by the Mecklenburg County Clerk of Superior Court, Estates Division. While our office cannot provide legal advice, we are happy to help you navigate the estates administration process. This video will provide a step-by-step guide for completing the application and oath to open a full estate for a decedent who did not leave a will or whose will cannot be probated. First, let's define some of the terms used in this tutorial with which you may not be familiar. Decedent, a person who has died. Intestate, the decedent died without leaving a last will and testament, or the decedent has left a will that cannot be probated. Administrator, the person in charge of the administration of the estate when no will has been probated. Public administrator, a county official placed in charge of the administration process of the estate. Heir, a person who is able to inherit from a decedent's estate when no will has been probated. Probate, the legal process in which the decedent's estate is administered. When is this process used? This process is used when the decedent has died either without a will or with a will that cannot be probated, and when assets are left in the decedent's name that are subject to probate, or an administrator is needed to complete unfinished actions on the decedent's behalf. This process may also be used when a lawsuit will be filed for or against the estate, for example, a wrongful death suit. Who may qualify as an administrator? The court will grant letters of administration to a person who applies and is qualified to serve. Applicants are appointed in the following order of priority: the decedent's surviving spouse, any heir of the decedent, any next of kin, with those persons of closest kinship taking priority, any creditor who is owed money by the decedent before the decedent's death, any person of good character residing in Mecklenburg County who applies, and any other person of good character that is not disqualified. Individuals are not qualified when the person is under 18 years of age. A court has determined the person is incompetent and the person remains with the disability. The person has been convicted of a felony and has not had his or her citizenship restored. A corporation has applied that is not allowed to act as a personal representative in North Carolina. The person has committed an act which, under the law, bars that person from inheriting from the decedent. The person cannot read or write. The person is someone who the Clerk of Superior Court finds unsuitable to administer the estate. The person previously held the role of administrator, but refused to carry out his or her duties in that role. Before the applicant can receive letters of administration, anyone who has priority to qualify as the administrator must renounce the right to do so. When this is done in writing, it is called an express renunciation. See the Renunciation of Right to Qualify tutorial for more information on this process. If a person with priority fails to apply within 30 days of the decedent's death, the clerk may send the person notice to qualify as the administrator. If the person to whom notice was sent fails to apply, or to request an extension of time to apply within 15 days, the clerk may find that the person has renounced their right to qualify as administrator. This is called an implied renunciation. If no person entitled to administer the estate applies for letters of administration within 90 days after the decedent's death, then the clerk may, in the clerk's discretion and without notice, enter an order of implied renunciation against all persons who had prior rights to apply for letters of administration, and issue letters to any suitable person. What must the applicant provide the clerk's office? The application for letters of administration and the oath affirmation forms must be completed and submitted to the clerk's office. Along with these forms, the applicant must submit the decedent's death certificate. The clerk's office also requires a family history affidavit to verify the identity of the decedent's heirs. There is a separate tutorial to help you complete this form. The General Court of Justice and facilities fees for this filing total $120. Acceptable forms of payment include certified check or money order. Cash, credit card, or debit card may be used if the payment is made in the courthouse. When the decedent has died without a will, then the person applying for letters of administration must provide the clerk's office with a bond in order to receive the letters. Under certain circumstances, the bond requirement may be waived. See the bond and waiver of personal representatives bond tutorials for more information on these circumstances. In addition to the forms mentioned, the applicant may also be required to submit one or more of the following forms. Renunciation of right to qualify. This form is used for the express renunciation referred to earlier in this tutorial. The signature of the person who is renouncing must be witnessed by an adult who is not a family member. Resident process agent. If the applicant is not a North Carolina resident, he or she must also complete the appointment of resident process agent form. This form names a North Carolina resident who will be the court's point of contact if the personal representative, once appointed, cannot be reached directly. This assigned person may then receive on the personal representative's behalf any documents the court may issue concerning the estate. The assigned person must sign the appointment form in the presence of a notary in acknowledgement of his or her willingness to serve as the resident process agent. There are separate tutorials available for each of these forms. How to complete the application for letters of administration. When filling out the forms, it is important to write the names in exactly the same way on each form. For example, if a person's middle initial is written on one form, be sure to include the middle initial in all other forms that require that person's name. Inconsistent names may cause difficulties after the applicant has obtained the letters of administration and submits them to banks, the DMV, or other agencies. If a name must be written in multiple ways, this may be done by writing all versions on the form with AKA between each version of the name to indicate that an alias is being used. Enter the county where this form will be filed. Enter the decedent's name, street address, city, state, and zip code. Enter the last 4 digits of the decedent's social security number and the county where the decedent lived at the time of death. Enter the decedent's date of death and the place of the decedent's death if it is different from the place where the decedent lived at the time of death. Enter the applicant's name, street address, P.O. Box if applicable, city, state, zip code, telephone number, and county and state of legal residence. If there is more than one applicant, provide this same information for the other applicants. You may use an attachment if there are 3 or more applicants. Enter the name, street address, P.O. Box, city, state, and zip code of the attorney who is helping the applicant with this process. If there is no attorney, leave this section blank. If an attorney was listed, enter the attorney's telephone number and, if known, the attorney's state-issued bar number. Confirm that the decedent lived in Mecklenburg County at the time of death, or left property or assets in Mecklenburg County, or was a motorist who died in North Carolina, although he or she was not a resident. Check the box to verify that there is no other application for probate or administration in any other court. In this section, you will check either box A or box B. Check box A if the applicant is entitled to apply for letters, or the applicant is applying after all other persons with a higher priority of appointment have renounced their right to apply. Check box B if there are others who have priority to apply for letters and have not renounced their right to do so. Since these persons have not renounced their right to apply, the applicant requests that notice of his or her intent to apply be sent to these persons. Box C should be used only by the county official appointed to the role of public administrator by the Clerk of Superior Court. Confirm that the applicant is not disqualified to administer the estate and has not rejected the right to do so. Identify any persons who are allowed to take a share of the decedent's estate. List their names, ages, relationship to the decedent, and mailing addresses. If exact ages are not known, print an A for adult or an M for minor in the age column. Once the front page of the form is completed, turn to the back page to complete the preliminary inventory of the decedent's estate. The first portion of the form includes the property of the estate. The estimated market value of the decedent's property at the time of the decedent's death is required for each field. If more space is needed, the information can be included on a separate sheet and attached to this form. List any accounts that are in the decedent's name only. Be sure to include the bank's name, each account number, and the amount remaining in the account. List any accounts that the decedent shared with another person, but that did not automatically transfer to the survivor upon the decedent's death. Be sure to include the bank's name, each account number, the amount remaining in the account, and the names of the other account owners. Also include the percentage of the account that the decedent owned. Include the percentage of any stocks, bonds, or securities owned solely in the decedent's name, or those that the decedent shared with another person if the person did not get full ownership upon the decedent's death. Provide the estimated market value for any of the following assets that are part of the decedent's estate: cash and deposited checks on hand, household furnishings, farm products, livestock, equipment and tools, vehicles, interest in partnership or sole proprietor businesses, insurance, retirement plan, IRA, etc., that are payable to the estate instead of directly to a beneficiary, notes, judgments, and other debts owed the decedent, miscellaneous personal property, estimated annual income that the estate will continue to earn after the decedent's death. Once all the amounts are listed, add the values in the far right-hand column together and enter the total amount for Part 1. The second portion of the form requires a listing of property which can be added to the estate if needed to pay claims. An estimated market value is required for each item of property listed. List any accounts that the decedent shared with another person if the survivor received full ownership of the account after the decedent's death. Be sure to include the bank's name, each account number, the amount remaining in the account, and the names of the account owners. Include the estimated market value for any stocks, bonds, or securities that were either transferable or payable directly to a beneficiary upon the decedent's death, or shared with another person who received full ownership after the decedent's death. Include the estimated market value for other personal property that is recoverable by law. This category includes the following types of personal property: accounts which are called trustee accounts in the signature card or deposit agreement, or in which the decedent otherwise established a tentative or taught-in trust. Securities registered in beneficiary form and automatically transferred on death. Property which the decedent gave to someone in contemplation of his or her own death, and property transferred by the decedent without receiving adequate consideration with the intent to hinder, delay, or defraud his or her creditors. If you believe there may be any property which falls into this category, you may wish to consult an attorney. Real estate owned by the decedent that is not identified in any other section of the form. List the value and attach a description of the real estate that includes either a full address or the parcel ID number. Once all the amounts are listed, add the values from this section together and enter the total amount for Part 2. Part 3 of the preliminary inventory includes other types of property that the decedent may have owned at the time of his or her death. Check the first box if the decedent was married and owned real estate jointly with a spouse. Check the second box if the decedent did not own real property with a spouse. Check the first box if there are any insurance, retirement plans, IRA accounts, etc., that the decedent made payable to a named beneficiary upon his or her death. Check the second box if the decedent did not leave insurance, retirement plans, IRA accounts, etc., that were payable to a named beneficiary. Check the first box if there is a potential wrongful death claim. Check the second box if there is not a potential wrongful death claim. When the form is completed, each applicant must sign the form. Do not sign until your signature can be witnessed by a person authorized to administer oaths. This will typically be a licensed notary public. Once the application for letters of administration is complete, the applicant must take an oath or make an affirmation to carry out the duties of his or her office faithfully and honestly. This is done by completing the oath affirmation form. Begin by entering the name of the county where this form will be filed. Enter the decedent's name. The applicant has the option to swear or affirm that he or she will faithfully perform the duties of an administrator. A person who swears to this oath would swear to God. A person who affirms would take a non-religious oath. Either version of the oath holds the same weight before the court. Read the statement in the first paragraph on the form carefully. If the applicant swears to this statement, check the first box located at the beginning of the first paragraph, as well as the first box located at the end of the paragraph. If the applicant affirms to this statement, check the second box located at the beginning of the paragraph, as well as the second box located at the end of the paragraph. The applicant will then choose his or her appropriate title when swearing or affirming. For an intestate estate, the applicant will check the box labeled Oath of Administrator. Read this statement carefully. If the applicant swears or affirms to this statement, indicate this by checking the appropriate boxes at the beginning and end of the statement. These will be the same boxes checked in the paragraph at the top of the page. When the form is completed, each applicant must print and sign his or her name on the form as the fiduciary. Do not sign until your signature can be witnessed by a person authorized to administer oaths. This will typically be a licensed notary public. When the application for letters of administration and the oath affirmation forms have been completed, signed, and notarized, submit the forms for filing along with these other previously mentioned items: death certificate, family history affidavit, a cashier's check or money order for $120 payable to Clerk of Superior Court. A renunciation of right to qualify form for any person with a higher priority of appointment than the applicant and who has signed the form to waive their right to qualify. If the applicant is not a North Carolina resident, the appointment of resident process agent form. A completed bond form if the administrator is required to provide a bond, or waiver of personal representative's bond if the bond can be waived. If the application is approved, the applicant will become the administrator of the decedent's estate, and the court will issue letters of administration as proof of this appointment. Upon receipt of the letters, the administrator is authorized to administer the decedent's estate by collecting the decedent's assets, paying any debts the decedent may have had, then distributing any of the decedent's remaining property to the decedent's heirs. The administrator is also authorized to take any other action authorized by law on the behalf of the decedent's estate. The administrator is obligated to act in a reasonable manner that will not result in any loss to the decedent's estate and must be diligent in settling the decedent's estate. If the administrator fails to act in the required manner, he or she may be removed from the role. After preparing your paperwork in accordance with this tutorial, you may bring your documents and the filing fee to the Mecklenburg County Courthouse and leave them with the Estates Department. Or you may mail these items to the following address: Clerk of Superior Court, Estates Division, P.O. Box 37971, Charlotte, North Carolina 28237. I hope this information has been helpful. We look forward to assisting you.